forget. Okay, and now you should see on the screen a slide that says here at the top, interesting cases. Right?
Yes, sir.
All right, very good. Okay, so this week we're going to be talking about the federal courts, and I always like to begin this topic. There's let me say it like this. This is one of those topics that we cover this semester that I think the authors of your textbook do a really good job with some aspects. In fact, they do such a good job with some of the aspects of the topic that I really like to use the time that we have in class to talk about other things. Specifically, for example, what I'm talking about here is they do a wonderful job, I believe, as well as can be done in an introductory course with the discussion about the organization of the federal courts. Okay, so that's one of those things that I think, okay, well, maybe we could be using our limited time that we have in class together to talk about things that maybe they don't develop as well, but at least maybe things that you might find a little bit more interesting. Of course, that's always really up to you more than it is to me. I don't know what your interests are. And, sometimes people, in my experience, what we're going to be talking about in today's class session, it's one of those things that over the years I've observed that students seem to find more interesting than perhaps some of the other things that we've been dealing with in the course, which is exactly why I am beginning here with the slide that at the top has the heading Interesting Cases, for lack of a better, more creative title for the slide. Maybe you'll find these cases interesting, maybe not. I want to run through a sampling of cases with you in the first part of today's class meeting. I'm going to resist the temptation that I always have to go into excruciating detail when talking about case law, because really the purpose of going through these cases is less to familiarize you with the specifics of the cases and really to talk at the end of the process to talk about what the cases have in common. Okay, so with that said, let me begin. This is just certainly not a random list of cases. I selected these cases deliberately to make the point that I want to make here today, and I could have just as easily selected another group of cases to make that point as well. But some of these cases you're going to be familiar with, you either are already familiar with or you're going to be familiar with. For example, you remember that week 5 material on civil liberties. Some of you have already worked your way through that material and taken the quizzes for week 5. Others haven't. This first case, for example, that I've already revealed to you is one of the cases that was introduced, the very important case, initial case dealing with the right to privacy. Okay? There's going to be a couple of cases on this list that we're going to talk about here in just a second that we deal with in class next week when we deal with the topic on civil rights. Okay? So some of these cases you're either already familiar with or you're going to be familiar with. Others may be entirely new to you and that we haven't dealt with in a previous context in this class or in a future context in this class. But again, the purpose is not to become intimately familiar with the details. I think you need to be familiar with the things that we say about them here in class. But as I said, we're not going to go into excruciating detail. Okay? So this first case, for those of you who have dealt with that week 5 material, you'll recall this is the initial case where the United States Supreme Court held that the Constitution protects the individual's right to privacy. Okay? Remember that the Constitution, the Bill of Rights specifically, does not specifically mention a right to privacy, unlike some of the other civil liberties rights that we're so familiar with. The right of free speech is explicitly in the First Amendment. The right of free worship is explicitly in the First Amendment. The right to keep and bear arms is explicitly in the Second Amendment. The right to counsel is explicitly in the Sixth Amendment. The right to be free from unreasonable searches and seizures is explicitly in the Fourth Amendment, etc. This is a provision of the Bill of Rights which the Supreme Court said is there, but even if it's not explicitly there. Okay, so again, I'm going to resist the temptation to go into a lot of detail here, but let me just remind you of the facts of this case, it involved the law of the state of Connecticut, or if you are learning about this case now for the first time, hold on to your chairs, okay? Try to avoid the jolt that you're about to get when I tell you what this case was about. This case involved a law of the state of Connecticut that made it a crime for a person to use birth control. Contraceptives were illegal under Connecticut state law as recently as the mid-1960s. Okay? There were other states as well. The birth control pill, condoms, IUDs, whatever other form of birth control was illegal under Connecticut law. Using birth control made one a criminal in the eyes of the state of Connecticut. Not only was it illegal under Connecticut law to use contraceptives, it was also illegal for another person to counsel someone in the use of contraceptives or to disseminate information about the use of contraceptives. And that was the provision of state law that was at issue here in this case. It involved the director of the Planned Parenthood clinic in one of the large cities in Connecticut. I assume Hartford, but I'm not absolutely sure about that. Jane Griswold was the director of the Planned Parenthood clinic, and you all probably are aware that that's what Planned Parenthood does. That's its organizational mission, right? To disseminate information about family planning. Invariably, that means information about birth control. So Griswold ran afoul of that provision of Connecticut state law. Griswold was tried and convicted under the Connecticut law, but appealed her conviction on the grounds that the decision to procreate, the decision between a man and a woman to make a baby or to not make a baby, is fundamentally a private matter, and that the state of Connecticut does not have a compelling interest that would permit it or authorize it to interfere with that decision making. Furthermore, that private decision-making sphere between the couple extends to the information provider, in this case, Planned Parenthood, Griswold, right? And the United States Supreme Court agreed that that is fundamentally a private matter. But what's really more important than that is that the Supreme Court says in this case that the Constitution protects that right to privacy, that there is in the Constitution a right to privacy, even if you don't see it explicitly in the Bill of Rights or elsewhere in the Constitution. It is, as Justice Douglas wrote for the majority of the court, in the penumbras of the Bill of Rights. And there's a lot that we can say there about that, but I guess the simplest thing to say in the interest of time is just that Justice Douglas is being somewhat poetic with his word usage, but he really just means that it's implied by the provisions of the Bill of Rights that are there. That there is enough evidence to conclude, based on what is in the Bill of Rights, that the framers of the Bill of Rights believed in a fundamental right to privacy. So I'm going to tick these off for you real quick. Okay. In the First Amendment, there's a provision protecting the right of the people peaceably to assemble. And just a few years earlier, in 1959, the Supreme Court decided a case called NAACP versus Alabama. In that case, the state of Alabama, remember this is at the height of the black civil rights movement in this country, the middle part of the 20th century. The state of Alabama was attempting to force the NAACP, the leading black civil rights organization in this country, to surrender its membership roles to the state. Now, one might wonder, well, why did the state of Alabama want the membership roles of the NAACP? Well, I think we can say pretty easily, particularly with the benefit of more than a half a century of historical hindsight, that the most likely explanation is that the state of Alabama wanted that information so that they could intimidate the members of the NAACP, to harass the members of the NAACP in an effort to stop them from agitating for changes in Alabama law to racially integrate Alabama and to promote racial equality. the people who were in political power in the state of Alabama at that time were almost to the person, perhaps, opposed to racial integration. They were opposed to changes in laws that would promote civil rights and racial equality, and they were going to put a stop to it by stopping the NAACP from doing the things that the NAACP was doing in those days. Sit-ins and protests and other sorts of organized activities that the NAACP, you're well aware of that period of our history that the NAACP was engaged in. But the Supreme Court said in that 1959 case that the right to peaceably assemble is virtually meaningless for the members of the NAACP if they don't have the right to be private in that association. That if the state of Alabama can compel them to surrender the membership rolls, they effectively don't have a right to peaceably assemble. So that was one very important precedent-setting case. Now, here we are in the mid-1960s, and the Supreme Court is essentially saying, well, we've already told you that there are hints of privacy in the Constitution in our 1959 decision in NAACP versus Alabama. But there are also other provisions of the Bill of Rights that suggest that the framers of the Constitution, the framers of the Bill of Rights believed in a fundamental right to privacy. There's the Third Amendment that prohibits the quartering of soldiers in private homes, suggesting that the framers of the Bill of Rights believed that a private domicile, a private home, was a private space that the government can't just come and barge in, take over. Okay? It's a largely moot provision of the Constitution today, of course, because we have a professional military and they have their own housing, but it was certainly very fresh in the minds of the framers of the Bill of Rights because that had been the practice of the British government during the colonial period. The Fourth Amendment provision against unreasonable searches and seizures, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Again, suggests that the government can't just come and barge in and look around anytime they want. That again, not only now is the home a private place, but your effects, like they can't come in and look through your file cabinet or your computer without a warrant, right? Which presumes that they have to go to a judge, that law enforcement officers have to go before a neutral judge and demonstrate that they have probable cause, meaning that there's a high likelihood that they're going to find what they think they're going to find, where they're going to look for it. You can look at these provisions of the Bill of Rights yourself, and you'll see that the Fourth Amendment indicates that stating the places to be searched and the things to be seized. So again, there's another bit of evidence that the framers of the Bill of Rights believed in a fundamental right to privacy. And finally, the Fifth Amendment, particularly, it's the part of the Fifth Amendment that deals with the right against self-incrimination. Everybody's familiar with the expression taking the fifth, right? Meaning that the government can't compel you to reveal things that you know about yourself and your activities if they might incriminate you, right? So now the court is saying, well, that provision of the Bill of Rights suggests that the framers believed that what you know about yourself up here is private, and the government can't just have that anytime it wants. Okay? So you've got a provision of the First Amendment, the Peaceably Assemble Clause. You've got the Third Amendment provision against quartering of soldiers in private homes. You've got the Fourth Amendment provision against unreasonable searches and seizures. And you got the Fifth Amendment provision against self-incrimination. That is ample evidence, according to the Supreme Court, a majority of the Supreme Court in this case in the mid-1960s, to suggest that even though they didn't explicitly write it into the Bill of Rights, the framers of the Bill of Rights believed in an individual's right to privacy. Now, if you couple the First, Third, Fourth, and Fifth Amendments, those provisions that I just ticked off for you, With the Ninth Amendment, that's pretty compelling, according to the Supreme Court, because the Ninth Amendment says that the enumeration of certain rights in the Constitution shall not be construed to deny or disparage others retained by the people. In other words, just because a specific right is not listed in the Bill of Rights does not mean that the people don't retain that right. You don't have James Madison, who we look to as being the primary architect of the Bill of Rights, was essentially saying that we don't have to list every single right. We can't list every single right. We might omit something. We might be omitting something here as we're writing this in 1789. But that doesn't mean that that should be taken, that the conclusion should be that if it's not listed in the Bill of Rights, it's not a right that the people retain. Well, that had never been the basis of any Supreme almost 200 years later, in 1965, 180 years later. And the Supreme Court says, oh, the Ninth Amendment, coupled with this other evidence that we've detailed for you that suggests that the framers believed in a right to privacy. Okay, so Griswold versus Connecticut is a very, very important case. It's hard to overstate the significance of Griswold versus Connecticut. You know, every time we have a president gets the opportunity to nominate a new justice for the United States Supreme Court, Donald Trump, for example, was able to nominate 2 justices to the Supreme Court, right? Okay, initially Neil Gorsuch, and then second Brett Kavanaugh. Oh no, he had 3. I almost forgot about Barrett, Amy Coney Barrett, right? 3. That's pretty good for a one-term president, you know, to have the opportunity to name 3 Supreme Court justices. And for all 3 of them, and for any of the nominees that Barack Obama put up before him or George W. Bush before him, going back through the 1990s and the 1980s, 1970s, you can bet that any time a nominee goes before that Senate Judiciary panel where they question the potential Supreme Court justice, the nominee, questions are raised about that person's views on Griswold versus Connecticut. It is inevitable. There are always questions about Griswold versus Connecticut, probably because many people agree that this is a significant case because it has so many implications. It had implications, for example, and we're going to talk about a couple of cases here in just a second, dealing with gay rights. Right? And it certainly had implications dealing with the abortion question. Is a woman's decision to terminate her pregnancy a private matter, or does the government have some compelling interest here? Of course, you all are probably sufficiently familiar with Roe versus Wade, but you know, Roe versus Wade, a lot has happened since 1973 when the Supreme Court handed down its decision in Roe. Okay? All right, questions about Griswold. So right to privacy. This is the first case where the Supreme Court says that there is a constitutional right to privacy. The question that has followed is, well, what then is a private matter and off limits to government restriction or government regulation? And we know that the court has said that some things are private matters, and other things that they've said are not, or that they may be private matters, but the government has a compelling interest that justifies some regulation. Okay? All right. This next case on the list is Mcculloch versus Maryland. Again, many of you may be familiar with this case. You may recall that this was a case that we addressed in the topic on federalism, although that was during week 6, and that was one of the weeks that was significantly affected by the week of canceled classes. That was week 5, and then we came back in week 6, and we had the topic on federalism. You'll remember this is the famous bank case. This goes back to 1819, so a little over 200 years ago. The case involved the Second Bank of the United States, the branch operating in Baltimore, Maryland. In this case, the state of Maryland had in effect imposed a tax on the operations of the Baltimore branch of the Bank of the United States. And the bank refused to pay. Mcculloch, James Mcculloch, the teller of the bank or the manager of the bank, refused to pay the tax. And the case went before the Supreme Court in 1819, raised 2 very important questions. There'll be a momentary pause as I deal with allergy symptoms. First question before the court in this case: does Congress have the power under the Constitution to establish a bank in the first place? Remember, this is the case where the state of Maryland had argued that Congress doesn't have the power to charter that bank because it's not in the Constitution. Right? Arguing the theory that whatever power Congress has must be delegated by the Constitution. And you're not going to find the word bank, or you're not going to find the phrase Congress has the power to charter a bank or establish a bank. And so the state of Maryland was arguing that since it's not delegated by the Constitution to Congress, it must be a power that is, who remembers? What's the phrase? Well, that is a provision of the Constitution that's very relevant to this case, but what's Maryland's argument? That's not Maryland's argument. Maryland's argument is that Congress doesn't have the power to establish this bank. It's not in the Constitution. If it's not in the Constitution, the power to charter banks must be a power that is reserved to the states by the 10th Amendment. Okay? Does that ring a bell? Okay. On that question, the Supreme Court said, Joanna, that, oh yes, Congress does have the power to establish a bank. It may not be explicitly delegated by the Constitution, but it is delegated by implication by the Necessary and Proper Clause. Congress has the power to make all laws which shall be necessary and proper for carrying into execution its powers under the Constitution and powers vested by the Constitution in any branch or department or officer of the United States government. So, for example, you'll recall that the court is saying that Congress may not have specifically under the Constitution to charter a bank, but it does have the power to raise and collect taxes. It has the power to raise and support armies and navies. It has the power to regulate commerce. It has all these great powers that are specifically delegated by the Constitution. And if you get all the way down to Section 8, it says it delegates to Congress the power to make all laws which shall be necessary and proper for carrying into execution the powers that are specifically delegated. Okay, so the answer to the first question is yes, Congress does have the power under the Constitution. And this is one of the first really good examples of the court using the doctrine of implied powers to uphold an action undertaken by Congress that's not specifically in the Constitution. The second question before the court is, does the state of Maryland have the power to impose a tax on the Bank of the United States? And so the court says that if the power vested in, if Congress's power to establish a bank is constitutional, and it is, we know that's the first question, right? The answer is yes, it is. Then the state does not have any power to impede or restrict, even by imposing a tax, the constitutional powers of Congress. That is by virtue of what provision of the Constitution? Anybody remember that? What provision of the Constitution says that if you have, according to the court, if you have an act of Congress that comes into conflict with an act of a state, how do they affect each other? Anybody remember what provision of the Constitution?
Congress supersedes whatever the state.
Yeah, if you have an act of Congress in exercise of its constitutional powers that comes into conflict with an act of a state, they affect each other as supreme and subordinate, with the Congress's power or the national government's power being supreme. I was trying to get you to say the Supremacy Clause, by virtue of the Supremacy Clause, which is, by the way, Article 6 of the Constitution. Article 6, Clause 2. Okay, so that is a very, very important case as well. Like Griswold versus Connecticut was in 1965, Mcculloch versus Maryland was extremely controversial at the time of the decision and remained so for some time. These three cases, again, to go back to some of the information that you're supposed to be dealing with for week 5, some of you have, some of you haven't. Okay, these three cases, Engel versus Vitale, involved the practice of public elementary and secondary schools in the state of New York beginning the school day with a non-sectarian prayer. Oops. School District of Abington Township versus Ship involved the practice, this came out of the state of Pennsylvania, a school district in Pennsylvania. Their practice was to begin the school day with a recitation of what Christians call the Lord's Prayer. And that third case, Murray versus Kirtland, involved the practice of public schools in Baltimore, Maryland, of having Bible verses. They would read Bible verses on a daily basis. That was part of the school regimen. Okay? All three cases, the Supreme Court said that constitutes an establishment of religion, beginning the day, or having an official prayer in public elementary and secondary schools, or having Bible readings, constitutes an establishment of religion, therefore violates the First Amendment, and it's not permissible. Very controversial decision at the time that the court handed down these decision in these cases in the early 1960s, and remained so for quite some time. In fact, it's not a continuous debate that we have, but over the decades, even down to the current day, episodically, these debates will be engaged in one place or another around the country about prayer in the public schools. Can you have, a student-led prayer? Can you have prayer before football games? Can you have prayer at commencement exercises? Right? That's a little bit more narrowly, focused question. Plessy versus Ferguson, an 1896 case. Some of you are familiar with this. If you're not, you will be after next week's classes, because it's one that we're going to be dealing with next week in our topic on civil rights. So I'm going to just give you a very, very quick overview of this case, because we're going to go into it in some detail next week. This case involved a man named Homer Plessy in Louisiana, who was arrested, tried, and convicted for violating Louisiana state law that prohibited, quote unquote, colored persons from boarding and sitting on railroad cars that were reserved for white passengers. Louisiana law required separate but equal, quote, separate but equal accommodations on the basis of race. Plessy appealed his conviction, arguing that the Louisiana state law that criminalized his conduct was a violation of the 14th Amendment Equal Protection Clause. Something, again, that we're going to talk about in depth next week. For now, let's just say that the Supreme Court disagreed, holding that just because the state of Louisiana required separate accommodations did not mean that they were unequal. What the Constitution required, according to the court, the 14th Amendment required, was equal, not integrated. So if you're familiar with this case, you probably know that it's the famous case where the Supreme Court upheld that practice that Louisiana and the other southern states, some other parts of the country, were already practicing after the Civil War, separate but equal. And of course, it justified another 60 years of racial apartheid in the United States. It really wasn't until this case that things began to change in a big way in that regard, because this is the case where the Supreme Court most directly overturned the separate but equal doctrine. This case, the Brown case, came out of Topeka, Kansas, and so it's more fully Brown versus the Topeka Board of Education. But it was one of several cases that the Supreme Court dealt with simultaneously, dealing with directly with practices in, I think, maybe 7 states, but indirectly in another 17 states, something like that. About half the states in the country had some sort of segregation policy in effect. And the court struck down those segregation practices in public elementary and secondary schools on the ground that separate but equal is inherently unequal. That's the phrase that the unanimous Supreme Court, through the pen of Chief Justice Earl Warren, so famously said, concluded that the fact of separating in and of itself suggests inequality. Why else segregate, if not to denote a position of superior and subordinate? Okay, so this really is a very important case. It's hard to overstate the significance of some of these cases that we're talking about here. This is certainly one of them. It's one of the May 17, 1954 decision. I'm not one of those professors that is really, I don't really have the idea that you should memorize a lot of dates in this course. Dates are something that, particularly in the age of the internet, you can look up, right, very easily. Google, date of Brown versus the Board of Education, Supreme Court decision. That's pretty easy to find out. But I think this may be one of those dates that, just as an American, you ought to know. Like July the 4th, 1776, May the 17th, 1954. It's probably in that group of dates, that December 7th, 1941, right? September 11th, 2001. Those are dates that you probably ought to, you hear May 17th, 1954, you probably ought to go click, 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 Brown versus the Board of Education. Okay, moving along. A couple of cases here. Taking these two cases together, even though they are separated by 16, 17 years, whatever the case is here, because they have pretty similar facts and the same question before the Supreme Court. But this time we find that the Supreme Court comes to very different conclusions in these cases. The first case came out of the metropolitan Atlanta, Georgia area. The Lawrence and Garner case came out of the metropolitan Houston, Texas area. Both cases involved gay men who were arrested and charged and convicted for violating state sodomy laws. The difference in these two cases is that on appeal, in the Bowers case, Bowers versus Hardwick, the defendant had his conviction upheld, excuse me, with the Supreme Court holding that it could find no protection in the Constitution for sexual preferences. But in the Lawrence and Garner case, the Supreme Court reversed, holding that the right to privacy is broad enough to protect the right of adults to determine who they want to have sexual relations with. So they struck down the Texas law as being a violation of the right to privacy under the Constitution. You know, there was one other difference between these two cases. The Georgia law made no distinction between acts of homosexual sodomy or heterosexual sodomy. So presumably under Georgia law, if it had involved a heterosexual couple engaged in such an act, then they would have also been treated as criminals under Georgia law. That was true in Texas as well for many, many, many decades. But the Texas legislature changed the law in 1991 to single out homosexual couples. It only applied to gay couples. Well, I should say gay people. Okay? So this is the case that I think probably more than any other single case really changed the direction of public policy in this country as it pertains to gay rights. If you go back and look at public opinion polls, for example, as recently as the 1990s, majorities of Americans indicated that they were opposed to what they might have, characterized as the gay rights agenda. But after the Supreme Court's decision in 1993, that began to change very rapidly. And we know, for example, that a majority of Americans today favor full civil rights protections without respect to sexual orientation. And in fact, the United States Supreme Court has gone as far as telling the states, holding that the states can't prohibit same-sex marriage. That was in a case in 2015 or 2016, something like that, in the Oberfels case. All right, questions about any of those? Almost done with the list, okay, and then we'll get to the question about what they all have in common, okay? These cases here, the 2003 cases, came out of the University of Michigan. Again, we may have an opportunity to deal with these cases next week. Just we'll have to see how time goes. The first case, one of these two cases, I always get the two confused. It doesn't really matter. One of the cases dealt with the affirmative action program in the undergraduate school, and the other one dealt with the affirmative action program in a graduate program. It may have been a specific graduate program like the law program or the medical program or something like that. I don't remember. They have just been general graduate studies. And in both cases, what the University of Michigan was doing was using a system that a lot of public universities used at the time, and that was called, kind of a race plus system, where they would award preference points to racial minority candidates, African Americans and Latinos specifically, in order to diversify the entering class, to diversify the undergraduate school or to diversify the graduate program. And the Supreme Court held in these cases that with respect to the undergraduate school, it was a violation of the 14th Amendment Equal Protection Clause, that the University of Michigan could not use race as a basis for determining who is qualified to enter its undergraduate program, but upheld the use of affirmative action graduate program. Bottom line is it left the question of whether or not race could be used at all, up in the air, undetermined. But I remember, it doesn't seem like that long ago to me, it's 20 years ago now, but I remember at the time when the court, handed down its decision in these cases, it was, of course, covered extensively by the national news media. So there was lots of articles to read and so on. I think the general consensus by many scholars and, people in the legal profession and so on who watched this issue was that the days of affirmative action were numbered, regardless. That the use of race as a factor in university admissions, it was only a matter of time before the court would say that it's not permissible. And that's what made this next case, Fisher versus Texas, so important. This case involved a young woman from Sugar Land, Texas, Abigail Fisher, whose lifelong dream it was to attend the University of Texas after she graduated high school. She was white. And many of you are probably aware that the state of Texas has a program that allows high school students who graduate within a certain percentage at the top of their class to enter any public university of their choice. What is that percentage now? It used to be 10%. It was 10%, the top 10% at the time. Is it still the top 10%? Maybe. I don't know. Okay, let's just say it is. It doesn't matter. The time it was the top 10%. Well, she was just outside of the top 10%. She didn't quite make the top 10% of automatic admissions to the school of her choice. So for everybody else who's not in the top 10, and that would include Abigail Fisher, at a place like the University of Texas, they're going to use some other criteria for determining who gets in and who doesn't get in. They can't let everybody in, is their view. Obviously, they can't do that, okay? But of the remaining pool of applicants, a very large pool, who are we going to let in? Well, the University of Texas used an affirmative action program to award preference points for racial and ethnic minorities. Again, specifically African Americans and Latinos. And to some degree, that disfavored white applicants and as well Asian American applicants. And Abigail Fisher claimed that she was being discriminated against on the basis of her race, that she was not being allowed to fulfill her lifelong dream of attending the University of Texas because she was white. It's the reverse discrimination argument, right? And so people eagerly awaited the Supreme Court's decision in this case. But much to their disappointment, in the first hearing of the case in 2013 on a technical matter, the Supreme Court remanded it back down to the lower court from which it originated. But then when it heard the case again in 2016, many people believed, okay, this is the case where the Supreme Court's just going to say, certainly people, particularly people who wanted to see the end of affirmative action, who said this is the case where the Supreme Court has got, it's going to say that affirmative action, you can't take race into account at all. But the Supreme Court actually upheld the University of Texas's use of race as a factor on a very narrow consideration. So we'll just have to wait for a broader decision of the court. If it comes, some people believe it'll come. It's just a matter of time. Okay, I think these might be the last two cases, if I remember correctly. These two cases involve the question of whether the right to keep and bear arms is a right of the individual. For many, many decades, the United States Supreme Court really refused to take up any cases that dealt directly with that question, leading many scholars and other observers to conclude that Well, that means that the Supreme Court wants to allow the states to decide, and that's why we had some fairly significant variations in state laws from one state to another. In some states, like Texas, let's say, pretty easy to get a gun. Legally, I'm talking legal, I'm not talking illegal, right? Legally get a gun, pretty easy in Texas. Liberal gun laws in Texas, meaning in this context, liberal means not so difficult to do, okay? Other states, like say maybe Illinois or New York or Massachusetts, much more difficult, okay? That, I think, is a direct result of the Supreme Court's refusal to really take up this question, take up a case raising this question. But that all changed, and it changed in a big way in 2008. That case, which came out of Washington, D.C., involved a ordinance of the District of Columbia, a local law in D.C., that prohibited the possession of a firearm that was capable of firing, assembled and able to fire. And the Supreme Court ruled that law to be unconstitutional, that it violated the Second Amendment, that this person, Heller, had the right under the Constitution to keep and bear arms. Now, you all know, I'm not telling you anything you don't know, the District of Columbia is not a state, it's not part of a state, it's a federal city, and so therefore governed generally under the laws of the United States, but they do have that local ordinance making power, but it's authority that comes essentially from Congress. And so the implications of the Second Amendment were much clearer when it came to, not that they were crystal clear, but they were at least somewhat clear when it came to the limitations of Congress in regulating firearms and therefore the District of Columbia. The next question was, what if it's a state that is attempting to restrict the ownership of firearms? Well, that question was answered just a couple of years later by the Supreme Court in a case involving an Illinois law that made it illegal to possess firearms and of a certain type, I suppose, but the court held this time that the right to keep and bear arms is a fundamental right of the individual and also protected against the authority of the states through the 14th Amendment Due Process Clause. So those two cases are very, very significant. Shouldn't probably surprise you that over the last decade, as you were becoming young adults, that the question of the extent to which states can restrict gun ownership would become much more hotly contested. So the individual questions will have to be worked out over time, but the precedent has been set that the right to keep and bear arms is like the right of free speech. It's a right that belongs to the individual. It's like the right of free worship. Just like you have the right to freely worship, you have the right to keep and bear arms as an individual. You see, up to that point, the debate had been about whether the Second Amendment was a right of the individual or was it a collective right? Was it an individual right or a collective right? Gun control activists, gun control advocates had always argued that it's not an individual right, it's a right of the community. Holding that, arguing that gun rights advocates conveniently leave out the part of the Second Amendment that says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Well, they argue, who's going to regulate the militia if not the state? All right? So they were saying the gun control people have always kind of argued, at least up to that point, that it's a right of the community. It's not a right of the individual. So that's why these cases are so important, because the Supreme Court is saying, yes, it is a right of the individual. Question online? Does someone online have a question? Guess not. Oh, I did have a couple more. Sorry. I think these are the last ones. Okay, these last two are a couple of free speech cases. First case is a 1993 case, REV versus the city of St. Paul, coming out of the state of Minnesota. It involved a local ordinance of the city of St. Paul that made it a crime to display any emblem or any symbol that was calculated to arouse fear or to intimidate any person on the basis of race, creed, color, religion, gender, or any other protected category. City of St. Paul, Minnesota had passed a law, a local law, that made it a crime within the city of St. Paul to display any emblem, the purpose of which, to display that emblem, would be to intimidate someone or to make someone fearful on the basis of race, creed, color, previous conditions. In other words, it was an effort on the part of the city of St. Paul to thwart what many people then and today would refer to as hate speech. Because they argue that hate speech invariably leads to hate crimes. The more hateful things that you tolerate out there for people saying, the more likely it is that you're going to get actual crimes committed against people. That's kind of the logic of these hate speech codes. But the Supreme Court said, oh, by the way, the case itself involved a teenage boy who was arrested, tried, and convicted under that city of St. Paul ordinance for burning a cross across the street from an African-American family. I don't know how much you know about that symbolism, the history of a burning cross, but if you're not familiar with it, if you don't understand what it is, well, you know, it was a tactic that was used by groups like the Ku Klux Klan to intimidate African Americans for a good chunk of our history after the Civil War, down well into the 20th century. So, you know, if you're African American in the United States, the sight of a burning cross directly across from your home might be considered intimidating or fearful. Anyway, the Supreme Court said that he has the right to say it. That it is symbolic speech. He's communicating a message, and the First Amendment protects his right to that speech. So they overturned the conviction in the St. Paul ordinance as being overly broad. And this next case here, Schneider versus Phelps, many of you are familiar with the Westboro Baptist Church. Does that ring a bell for anybody? Nobody? I'm not sure where the Westboro Baptist Church is located. For some reason, I want to say Kentucky or maybe South Carolina or someplace like that. They were in the news a lot during the last decade. One of the things that they would do is go to the funerals of military people, service people, and protest loudly and disrupt the funeral services. Okay, obviously something that the grieving family and friends and so on found quite offensive at best. But does anybody know why they were protesting? What was their basis of their protest? It didn't just happen one time. It happened numerous times. Anybody know what the concern that the Westboro Baptist Church was attempting to express? I think in general, I hope I'm not misrepresenting their view. I'm going to try to be as dispassionate about it as possible, but I think their view is that the United States and its tolerance of the homosexual agenda is intolerable in God's eyes, and as people of faith, they believe that they needed to make that known. I don't know why they picked military funerals. Maybe because they knew that's where the cameras would be. Who knows? But in one incident, this one that we have here, the family had asked local law enforcement officials to remove the protesters. The law enforcement did that, and the Westboro Baptist Church, its members, I think there were citations issued for disturbing the peace, for example. They countered that that was a violation of their free speech rights under the First Amendment. Anybody know what the Supreme Court said here? Do they have a right to protest? Make their demonstrations loud in very controversial ways? The Supreme Court said, yeah. The Supreme Court said that they have. The Supreme Court's general view on the right of free speech seems to be that the whole purpose of the right of free speech in the First Amendment is to protect the rights of people who are saying things that are unpopular. Burning a flag, for example, is a way of making a statement that is very unpopular, but that's why we have the First Amendment. Nobody, the court said in that famous flag burning case, nobody is going to try to punish you for waving your flag proudly on July the 4th and sending the message that you're a proud, patriotic American. You don't have to worry about somebody coming to arrest you and put you in jail for that statement. I'm a proud, patriotic American. But neither should people who are being critical. Neither should people who are engaging in dissent. Should they be criminalized for their speech? Okay. Questions, thoughts on those cases? Oh, guys, this list just never ends. Good heavens. I'll tell you what, I'm going to end it at that. There was a couple more left, but in the interest of time, let's finish this up so we can at least set the table for next time. Okay? All right, so these cases I put under the heading of interesting cases. Maybe you found them interesting, maybe you didn't. I don't know. But what's really more important than them just being interesting is a couple of things. First of all, as I hinted at a couple of times during the presentation, that all of these cases were certainly very controversial at the time that the Supreme Court handed down its decision. And some of them have remained controversial for decades, for long periods of time, because the controversy may ebb and flow, but it hasn't gone away. More importantly than the fact that they were controversial is that they do have a common thread. Even though some of the cases are about free speech, and some of the cases are about gay rights, and some of the cases are about separate but equal, and some of the cases are about prayer in the public schools, or whatever other specific issues that we dealt with here, they all have a common thread, and that is that in each instance, there was a criticism leveled at the court that the court was engaging in judicial policy making, and that is an improper role for the courts in our system of government. Okay? One very important line of criticism that all of these cases have in common is the critics are saying that the court is not supposed to engage in judicial policy making. It is, in their view, a violation of a fundamental principle of our system of government, namely separation of powers, that you have three branches of government, the legislative branch, the executive branch, and the judicial branch, and it is the purview of the legislative branch and the executive branch in combination to make policy. It is not the purview of the courts to make policy. Everybody with me? You hear this argument today? We've heard it. We've heard this argument for decades. In other words, it cuts to the very fundamental and a very important question: what is the proper role for courts in our system of government? The critics are saying, well, it's not to make policy. They're supposed to simply adjudicate cases. That when you have conflicts that arise under law made by the legislature and the executive, the courts are supposed to sort out what the facts of the case are and apply the law. They're not supposed to substitute their view of what is good policy for that of the very people who are elected for that purpose. You understand? This is a very fundamental argument that we have engaged in our system of government now for many decades. What the critics are saying, to put it just a little bit differently, not suggesting to you that they're right, I'm just trying to articulate the argument for you, okay, is that why should 9 unelected justices in Washington, D.C. be able to tell us here in Texas whether or not we should have prayer in the public schools? That is a policy decision, the critics argue, that should be made by the legislature or even better, the local school districts. That's the conflict, the sort of a very fundamental conflict that we have here, the debate that we have here. What is the proper role for the courts? So, if you think about each of these cases that we talked about here, I'm not going to go back through the entire list again, but let's just take, maybe a couple of them. Like, let's take these these school prayer cases. Who is most likely to level that allegation of policymaking against the court? And I'm not asking you for individuals' names. I'm asking you for which side of the debate over prayer in the public schools. Is it people who support prayer in the public schools, or is it people who are opposed to prayer in the public schools who are most likely to make the argument? Oh, there goes the Supreme Court again, substituting its vision of good policy or its version of good policy for that of the very people who are elected to make those decisions. Who's most likely? I kind of already given you the answer on this one, hinted the answer on this one, right? It's
people who support.
Yeah, the people who want to have prayer in the public schools, all right? And what are the people who are opposed to prayer in the public schools likely to say on that matter? They're going to say, the court's not making policy, it's just upholding the Constitution. That's what the court's supposed to do. It's supposed to uphold the Constitution, all right? And how about on the question of, let's say, how about these, right? Lawrence and Garner versus Texas in the Bowers case. The question about whether the act of sodomy, same-sex sodomy to be precise, should be a criminal act. What are the critics? Who are the ones who are going to say, oh, the court's overstepped its authority in Lawrence and Garner versus Texas? The people who want to criminalize that behavior, right? Who want to keep that as a criminal behavior under state law, right? And the people who want the court to strike it down are just saying they're not making policy, they're upholding the right to privacy under the Constitution, okay? All right, so that's kind of the pattern that we have here in these cases, right? Now, look, let me wrap up on this point. As a political scientist, I'm going to tell you that the court does, at least from time to time, make public policy. Okay? There's no question that at least some of the decisions of not only the United States Supreme Court, but other courts can be characterized as policy-making decisions. But we have to have a more objective set of criteria, other than just whether we agree or disagree with the decision of the court based on the merits of the case. You follow what I'm saying? As political scientists, It can't just be, oh, well, we believe there should be prayer in the public schools, so therefore it's an example of judicial policymaking. Or we believe that our society ought to be segregated on the basis of race, so therefore it's an example of judicial policymaking, right? We have to have an objective set of criteria. So that's what I want to do in Thursday's class meeting, is outline and elaborate those criteria for saying whether this decision or any other decision of the United States Supreme Court, or any other court for that matter, can be characterized as an example of policymaking. Okay. Took longer to get through that list than I thought it would, but that's okay. You know, I think it'll serve our purposes to have discussed them. Okay? We'll see you on Thursday.
You know, it dawned on me another answer to that question.